Hi, I'm David Fraser, Privacy Lawyer, and in today's episode we're diving into the joint investigation by Canada's 4 private sector privacy commissioners, federal, Quebec, British Columbia, and Alberta, their investigation into TikTok. Now, this is a big one. It raises some interesting and troubling questions about jurisdiction, children's privacy, reasonableness, consent, and what it actually means to protect privacy. In my view, at the end of the day, the commissioners have imposed an almost impossible standard on TikTok, one that ironically would actually reduce privacy for many users. So let's unpack what they found and why I think, they might have gone a little bit too far. I'll note that the finding is more than 30 pages long, with almost 200 paragraphs. This should be treated as an overview and not a deep dive into all the minutiae. So TikTok Pte. Limited, a Singapore-based company owned by ByteDance, operates one of the world's most popular social media platforms. In Canada alone, they say about 14 million monthly active users scroll, post, and engage on TikTok. This investigation examined whether TikTok's collection, use, and disclosure of personal information complied with PIPEDA, Quebec's Private Sector Act, and the provincial privacy statutes of Alberta and British Columbia. A key preliminary issue is jurisdiction. The British Columbia Personal Information Protection Act is a little bit quirky. It says, application. Subject to this section, this act applies to every organization. And then goes on and says, this act does not apply to the following, including the collection, use, or disclosure of personal information if the federal act applies to the collection, use, or disclosure of the personal information. TikTok argued that because of this, only one of the Federal Act or the British Columbia Act could apply. In my view, the response to this argument by the commissioners is a bit facile. At paragraph 22, privacy regulation is a matter of concurrent jurisdiction and an exercise of cooperative federalism, which is a core principle of modern division of powers jurisprudence that favors, where possible, the concurrent operation of statutes enacted by the federal and provincial levels of government. PIPA BC has been designated or designed to dovetail with federal laws in its protection of quasi-constitutional privacy rights of British Columbians. The legislative history of the enactment of PIPEDA and PIPA BC and their interlocking structures support the interpretation that PIPEDA and PIPA BC operate together seamlessly. It then goes and says at paragraph 23, PIPA BC operates where PIPEDA does not, and vice versa. In cases such as the present, which involve a single organization operating across both jurisdictions with complex collection, use, and disclosure of personal information, both acts operate with an airtight seal that leaves no gaps. An interpretation of Section 3.2c that would deprive the OIPC of British Columbia of its authority in any circumstance the OPC also exercises authority is inconsistent with the interlocking schemes and offends the principle of cooperative federalism. Well, in my view, this has nothing to do with cooperative federalism. In this case, they're waving their hands instead of engaging in a helpful legal analysis. The British Columbia legislature chose to say that if PIPEDA applies, PIPA will not. And the federal government said if PIPA applies, PIPEDA doesn't. But this is not about constitutional law. The commissioners could have articulated a much more clear and straightforward response to this argument. TikTok collects personal information across Canada, in British Columbia, and elsewhere. PIPA applies to, quote, the collection, use, and disclosure of personal information that occurs within the province of British Columbia, unquote. This is from the federal regulation regarding PIPEDA's application in British Columbia. So in this joint investigation, BC's PIPA applies to the personal information of British Columbians, and PIPEDA applies to the personal information of individuals outside of British Columbia. They could have just said that, but they didn't. They did say it was about overlapping protections and not silos, and I think that's incorrect. The British Columbia Act and the federal regulations clearly say this is the BC Commissioner's silo and this is the federal Commissioner's silo. So after that, the investigation moved forward jointly, setting the stage for 3 major questions. First question, were TikTok's purposes in collecting, using, and disclosing personal information appropriate? Second question, was user consent valid and meaningful? The third question is, did TikTok meet its transparency obligations, especially in Quebec? The first issue asked whether TikTok was collecting and using personal information, particularly from children, for an appropriate and legitimate purpose. Now, TikTok's terms forbid users under the age of 13 or 14 in Quebec, but the commissioners found that its age assurance tools were largely ineffective. The platform relied mainly on a simple birthday gated sign-up plus moderation for accounts flagged by other users or by automated scans. As a result, TikTok said that it removes around 500,000 underage Canadian accounts each year, but regulators concluded that many more likely go undetected. Now, it seems to me that terminating 500,000 accounts a year because they think the user may be underage is a pretty strong sign that the company is sincere in its desire to not have kids on their platform. They also noted TikTok already uses sophisticated facial and voice analytics tools for other purposes, like moderating live streams or estimating audience demographics, but not to keep kids off the platform. The regulators ultimately want TikTok to repurpose these tools for age estimation. The commissioners found that TikTok was collecting sensitive information from children, including behavioral data and inferred interests, without a legitimate business need. In their view, that violates the reasonable person standard under PIPEDA Section 5 Sub 3 and the comparable provisions in the provincial laws. Now, this part makes my head hurt a bit, because the regulator said, quote, "In light of the above, as summarized in paragraph 64 to 66, we determined that TikTok has no legitimate need or bona fide business interest for its collection and use of the sensitive personal information of these underage users. Nor is this collection and use in support of a legitimate issue in the context of Quebec's Private Sector Act. It is therefore our finding, irrespective of TikTok's assertion that this collection and use is unintentional, that TikTok's purpose for collection and use of personal information of underage users are inappropriate, unreasonable, and illegitimate, and that TikTok contravenes subsection 5.3 of the PIPEDA, section 4 of Quebec's Private Sector Act, and sections 11 and 14 of PIPA BC, and sections 11 and 16 of PIPA AB. It's clear that TikTok does not want children on its platform, and they take active steps to keep children off its platform. The regulators were clear that they didn't think the measures taken were adequate, but I don't see them saying that TikTok was insincere about this. So they find that TikTok's purposes for collecting personal information from children was not reasonable. But TikTok had no purposes for collecting personal information from children. If kids made it through the age gate and didn't have their account deleted, TikTok still does not want that data. They essentially said, your collection of personal information that you do not want and do not try to get is unreasonable. Okay, I guess that's their view. So the second issue focused on consent, whether TikTok obtained valid and meaningful consent for the tracking, profiling, targeting, and content personalization. And the commissioner said that it did not. They found that TikTok's privacy policy and consent flows were too complex, too long, and lacked the upfront clarity needed for meaningful understanding. In particular, they said key information about what data was being collected and how it was used wasn't presented prominently. They said important details were buried in linked documents. And they also found the privacy policy was not available in French until the investigation began. And users were never clearly told how their biometric information, their facial and voice analytics, was used to infer characteristics like age and gender. Even for adults, the commissioner said that consent wasn't meaningful because users couldn't adequately understand the nature and consequences of all of TikTok's data practices. And for youth between 13 and 17, TikTok mostly relied on the same communications used for adults. They didn't have a simplified, age-appropriate explanation about how data is collected, used, or shared. Under the commissioner's reasoning, because the data involved is often sensitive, revealing health, sexuality, or political views, TikTok needed express consent. And they found the platform failed that standard. They said at paragraph 81, additionally, while users might reasonably expect TikTok to track them while on the platform, which they can use for free, it is our determination that they would not reasonably expect that TikTok collects the wide array of specific data elements outlined earlier in this report, or the many ways in which it uses that information to deliver targeted ads and personalize the content they're shown on the platform. Many of these practices are invisible to the user. They take place in the background via complex technological tools such as computer vision and TikTok's own machine learning algorithms as the user engages with the platform. Where the collection or use of that personal information falls outside of the reasonable expectations of an individual, or what they would reasonably provide voluntarily, then the organization generally cannot rely on implied or deemed consent. Now, in my view, the commissioner's reasoning is generally coherent, but I'm not sure that it directly leads to a requirement for express consent. So consent can be implied where the individual understands what information is being collected and how it will be used, and it makes sense to take into account whether the individual expects that collection or use. The main issue here is that the collection and use of information was outside the reasonable expectations of the individual. TikTok's data practices are part of its secret sauce that ultimately has led to its success. Now, following the reasoning of the commissioners, if TikTok had better calibrated the expectations of its users, then it could have relied on implied consent. The Quebec Commissioner took things a little bit further because under Quebec's Private Sector Act, organizations must inform the person concerned before collecting personal information. The CAI found TikTok failed to highlight key elements of its practices and was using technologies like computer vision and audio analytics to infer users' demographics and interests without adequate disclosure. This is the same technology that they want to use for age assurance, by the way. So the CAI also found that TikTok allowed features that could locate or profile users without an active opt-in action, violating Quebec's rule that privacy settings must offer the highest level of privacy by default. Now, here's where I think the commissioners overall overreached. They're effectively holding TikTok, and by extension every global digital platform, to a near impossible standard. First, on age verification, to exclude all under 13 users, TikTok would need to collect more information from everyone. Things like government-issued ID or facial age scans, which they're suggesting. That's exactly the kind of sensitive biometric data that privacy regulators have previously warned against. So in demanding better age assurance, the commissioners are actually requiring more surveillance and more data collection from all users, adults and teens alike. While it may be protecting the children, like so many age assurance tools, it's actually privacy invasive. Now, second, on consent and transparency, privacy regulators have long said that privacy policies are too long, too legalistic, too hard to read. Yet here they criticize TikTok for not providing enough detail, for not being even longer and more comprehensive. So which is it? We can't reasonably expect the average user to read a novel-length privacy policy, but that's what these findings effectively require. And third, the commissioner's reasoning conflates complexity with opacity. TikTok's algorithms and personalization systems are complex. That's the nature of modern machine learning. That's also their secret sauce. And explaining them in plain language might be a noble goal, but demanding a full technical manual risks burying users in noise. In my view, this decision reflects a growing tension in privacy regulation between idealism, the desire for perfect transparency and perfect protection on one hand, and pragmatism on the other, the need for solutions that actually enhance user privacy without breaking the internet. The regulators seem to be demanding a standard of perfection in a messy and complicated world. These laws can be applied reasonably and flexibly. And one final thing to note, the regulators say that information provided to support consent from young people over the age of 13 or 14 has to be tailored to the cognitive level of those young people. It means it has to be subjective in light of the individual. But the Privacy Commissioner of Canada is currently arguing in the Supreme Court of Canada against Facebook that consent is entirely objective based on the fictional reasonable person who is not a young person. They should pick a lane. So where does this leave us? TikTok has agreed to implement many of the Commissioner's recommendations: stronger age assurance tools, better explanations, a new teen-friendly material, and improved consent flows. But whether these measures will truly protect privacy or simply demand more data from more users is a question that regulators and platforms still need to grapple with. So if you found this analysis useful, please like, subscribe, share, and let me know in the comments whether you think the Commissioners got it right. I'm David Fraser, and thanks for tuning in.